uploading on YouTube, and a few seconds.
Yeah, Mike, we have over 350 people registered for this.
Okay, we are live now.
Oh yay, oh yay, oh yay. I call the Space Court Foundation video series to order. Welcome. My name is Chris Hearsey, and I am the co-founder and chair of the board of directors for the Space Court Foundation. Thank you for joining us today to continue our video series on the Artemis Accords and the future of space governance. The Space Court Foundation is a 501c3 educational nonprofit corporation that promotes and supports space law and policy education and the rule of law. The Space Court Foundation produces educational materials and scholarship through the administration of two major projects, Stellar Decisis and the Space Court Law Library Project. The foundation engages in partnerships and collaborations that help grow greater awareness of space law and how disputes in space may be resolved as humans venture further from Earth in the not too distant future. For more information about our mission, programming, and internship program, we ask that you visit our website at spacecourtfoundation.org. Today, our moderator is Daniel Porras. Daniel is the Director of Strategic Partnerships and Communications at the Secure World Foundation. Previously, Mr. Porras was the Space Security Fellow at the UN Institute for Disarmament Research, where he focused on political and legal issues surrounding space security. He's also been the resident technical expert for multiple UN bodies working on space security issues, including the Group of Governmental Experts on the Prevention of an Arms Race in Outer Space. Thank you, Daniel, for putting this excellent program together, and thank you, Letitia Zarkhan, for helping put another great series together. With that, I turn over the program to Daniel.
Thank you very much, Chris. It's a pleasure to be joining everybody virtually once again, but it's still exciting that we're able to pull together so many great authorities on some of these issues that we want to be discussing so quickly. And in fact, we got a big surprise as we tweeted out earlier this morning. Dr. Mike Gold himself is going to be joining us as a special guest to introduce the Artemis Accords, which is what we're here to discuss today. Why do we want to discuss the Artemis Accords? Well, it turns out that, for many of us, this is the Space Court Foundation. We are lawyers. And while the United States seems to push boundaries and NASA in particular keeps taking us to new places with technology, we're also doing that, or NASA's also doing that with law. They're finding new ways to push the boundaries of what we consider to be the framework for how we're going to be doing space activities. And over the last couple of months and weeks and even days, we've just seen a lot of conversations coming up, and it's a great opportunity to be able to bring so many experts and authorities together to talk about some of these issues and make sure that we're all seeing these things from different perspectives, and to try and figure out how can we take these opportunities for lunar exploration to bring each other together and to grow our understanding about the universe. So with that, just a couple of quick points. We are recording, so all of this is going to be posted online later on. If somebody misses it, or if you want to refer back to it, you can come and check it back out. Everyone that is speaking here, there are at least 3 of us who are associated with the Secure World Foundation. But just remember that all the things we're going to be talking about are our personal views, except for Mike's. We are speaking for ourselves and not necessarily representing the views of our institutions. Other than that, I think we're going to have a great program. We're going to aim for about an hour and a half, maybe 2 hours if things are going really well. If you have questions, please feel free to put them in the Q&A. We can monitor the chat as well, but specifically for questions, please use your Q&A tab below. And with that, I would like to introduce a friend and someone who's been in this business for quite some time and has helped to shape the way that space activities are taking off today, Dr. Mike Gold. He's the Acting Associate Administrator for the NASA Office of International and Interagency Affairs. He's also the former VP of Civil Space at Maxar Technologies, and from when I first learned about him, he was formerly a part of Bigelow Aerospace. So if any of y'all remember the big inflatable habitats that got attached to the space station, that was them. So it's my pleasure to invite Mike to join us and to tell us, Mike, what are the Artemis Accords?
And let me tell you, despite leaving Bigelow Aerospace, I'm more inflatable every day. So I continue to practice what I preach. Hey, Daniel, thank you so much for that kind introduction. Again, it's so nice to be with you and Chris Hearsay and Chris, all the Chris's, Goyo, Una, such a terrific event. Forgive me for gate crashing, but there's no Artemis Accords discussion I don't want to get involved in. And later on, I will have to leave, but will be replaced by the talented and smart, another terrific space attorney, Gabriel Swinney, from Department of State. And, we start out talking about lawyers and law, and let me get myself in trouble immediately by saying, I always think the engineers have the easy job. They just deal with physics. There's no rocket equation for international relations or the Outer Space Treaty. So I really appreciate the Space Court Foundation, Secure World, taking a look at these critical issues that I believe are as important as any of the technical challenges that we'll face. Hence the Artemis Accords. So, well, Tisha, if someone can bring up my slides, I'd love to share a few thoughts with you about the Accords and then take some questions. And before we even get into the Accords, I'd like to take a step back to the International Space Station, which has now celebrated 20 years of a continuous human presence, terrific victory. I think is deserving of a Nobel Peace Prize. So please, everyone, get behind that effort. And not only did the ISS blaze new territory technologically, but it did so legally and diplomatically as well. And the legal framework, as many of you may be aware, for the ISS is the IGA, the Intergovernmental Agreement. And as we move forward to the moon under the Artemis program, and I assume nearly everyone, if not everyone listening to this, is familiar with Artemis, but that's NASA's program to land the first woman and the next man on the moon by 2024 to create a permanent, sustainable human continuous operations on the surface of the moon as a way of pushing forward and developing the technology and expertise to mount a historic human mission to Mars. So that's Artemis. And a key part of Artemis, and particularly of sustainability, is the Gateway, which will be an orbital outpost around the moon that will enable more robust surface operations and really create that infrastructure for sustainable both public and private sector activities on the moon. And we're going to be leveraging the IGA for Gateway because whether you're a space station in low Earth orbit or an orbital outpost around the moon, the processes, the systems for operating a space station that a number of countries are participating in is relatively similar, if not identical. So we're currently working on MOUs that will leverage the IGA to partner with Canada, the European Space Agency, and Japan to operate the Gateway. But as we move beyond Gateway to the lunar surface, and even beyond lunar surface on the way to Mars, there's a whole series of new dynamic opportunities that we have to explore the moon. I believe that the moon has yet to reveal many of her amazing mysteries that we're going to get to learn, not to mention our future exploration of Mars. And those dynamic new opportunities will require a dynamic new legal framework to support those activities. And that's where the Artemis Accords come in. So if we go to our next slide, please. The Accords are based fundamentally in the Outer Space Treaty, that the Accords reinforce our multilateral commitments, beginning with the Outer Space Treaty, but including the Registration Convention, the Agreement on the Rescue of Astronauts, long-term sustainability guidelines, etc., and then go a step further to implement those obligations. There are a couple of places where we've got some principles that go beyond the Outer Space Treaty in terms of common practices, such as the public release of scientific data that NASA has always done. And I'll get into those in more detail as we go through the specifics of the principles. But before we do that, I just want to emphasize what Artemis Accords are and a little bit what they aren't. So the Accords are bilateral partnerships to enact activities underneath the Artemis program. Just like with any NASA activity or any NASA program, we're going to have international partners. The only difference between the Artemis Accords agreements and any other traditional partnership is that we're emphasizing principles a bit more than you would normally, because when we go forward to the moon and we execute activities under Artemis with our partners, we want to reinforce how important respect for the Outer Space Treaty, these other multilateral agreements are, so that we can all continue to abide by our existing multilateral obligations, and then take our experiences and use them to inform future multilateral discussions that we might have in forums like COPUOS or the Hague International Space Resources Governance Working Group, etc. Taking a page from the Outer Space Treaty, which is a treaty of principles, we think that works very well. We don't want to be too prescriptive. There's still a lot that we need to learn. So we thought the principles was a great way to proceed. The Outer Space Treaty is over 50 years old, doesn't look a day over 35. It's worked very well for the Outer Space Treaty. And we just wanted to honor the Outer Space Treaty, both in substance and in structure, hence going forward with principles. So with all that being said, let's get into what the principles of the Accords are. If we could go to the next slide, please. And it begins with peaceful purposes, that in the end, one of the primary, if not the primary goal of the Accords is to avoid conflict. Many of you who know me personally know that I'm a big Star Trek fan, and I certainly want the future to look more like Star Trek and less like Star Wars, which is why one of the fundamental principles of the Outer Space Treaty and of the Accords is that if a space agency is going to join NASA in pursuing programs underneath Artemis, they need to do so for peaceful purposes only, that they should have a civil space agency that will work with us on peaceful activities per the requirements of the Outer Space Treaty. Next slide, please. Another important aspect of the Accords is transparency, and it gets back to the point of avoiding conflict. The more that we know about what our other countries are doing, what each of us are doing, the better off we're going to be to avoid conflict, to maintain peace, and to grow private sector opportunities. So as part of the Accords, we're going to ask partners to be as transparent as possible relative to their plans, policies, and activities. Next slide, please. Interoperability. So this is one that isn't explicitly in the Outer Space Treaty, but we believe it's very much in the spirit of the treaty. It's important not only for people to be able to talk to each other, but for systems and hardware to be able to communicate. We want to set up an environment that's conducive to peaceful operations and commercial growth. And to the extent that systems are interoperable, we believe it will be helpful for both of those things. So if spacesuits can talk to each other, if spacecraft can talk to each other, we think that benefits everyone. To be clear, we're not being prescriptive here. We don't have all the solutions in terms of how to make everything interoperable. But we wanted to point out this is an important principle, and we're at least going to try on a global basis. And we'll talk to countries even outside of any Artemis Accords agreement. There's some great work I know that Secure World is doing with Confers and others to try and look at how can we create an interoperable system so that globally all of our different technologies and hardware can talk to each other. Going to the next slide, please, because it demonstrates why interoperability is important. Emergency assistance. Here, again, we just want to emphasize the importance and responsibility that we have as a spacefaring nation to rescue astronauts and reinforce our agreement and our support for the agreement on the rescue of astronauts. We are simply trying to reinforce that. We are not trying to dilute in any way emergency assistance. If anything, we're trying to emphasize it, maybe even try and go a step forward. But again, while the Accords are bilateral in nature, the principles need to be multilateral. So any country that joins us in Artemis needs to agree to the same language. So we're working with the international partners in terms of what's acceptable to them on these principles. And again, we want people to reinforce their support for emergency assistance. It's so important. And here you see where there's synergy among the principles of the Accords, that the more interoperability we have with hardware, the more likely emergency assistance from different nations is to be safe and successful. So we think Rescuing astronauts is an important principle to have. And again, we just want to try and reinforce what multilaterally many nations have already agreed to relative to the rescue agreement. Next slide, please. Registration of space objects, another critical and fundamental principle that we can't avoid harmful interference. We can't get to issues of liability if we don't have proper registration. Registration is the foundation upon which everything else is built. And that's why we felt it was important to reinforce with the Artemis Accords that any country that joins NASA in working on Artemis should be a member of the registration convention, and if not, should join as soon as possible. And I also want to emphasize, as we talk about different aspects of the Outer Space Treaty, that we're obviously picking a few out to reinforce, but that should not be taken in any way, shape, or form to say that we don't think anyone should abide by all of the different principles of the Outer Space Treaty. We just wanted to reinforce some principles that were going to be particularly applicable to our activities underneath Artemis, registration of space objects being a very important one. Next slide, please. Release of scientific data. This, again, is something that isn't required explicitly within the Outer Space Treaty, but we believe is very much in the spirit of the Outer Space Treaty and what responsible spacefaring nations should look like. NASA has always publicly and fully released its scientific data, and we're going to ask any country that partners with us on Artemis to do the same. We think this is important so that all nations and all people can enjoy the benefits of the scientific data from exploration. And to be clear, all of this will be revealed publicly on our website, accessible to anyone with an internet connection. So again, a very important principle that we think to release this scientific data as widely and as publicly as possible. NASA has always done this, and we will be asking partners who join with us on Artemis to do so as well. Next slide, please. Protecting heritage. Again, we could have spent 12 pages in terms of determining what a heritage site is, how you can respect it, distances, etc. But per the principal structure, we just wanted to cite that it's important to respect heritage. We respect heritage and historic sites here on Earth, as well as historic artifacts, and we should do so on the moon and other celestial objects as well. We don't have all the solutions for how to solve this issue in terms of protecting heritage, and like many principles of the Accords, while we're going to implement this and respect it for our operations, so if we've got a rover that we're partnering with a country and it gets close to a heritage site, whether that's a human spaceflight site, as is in this picture, or a robotic rover of some sort, that will make sure that we do not create any harmful interference with that site. But we hope that this will kick off a multilateral conversation where we can bring our experiences and that of the other spacefaring nations, can come to a group like COPUOS or other forums and talk about, is there more explicit rules that we could develop relative to protecting heritage? Is there a larger multilateral agreement that we could all come to? So we think this is important. We'll look forward to having further discussions about if there's a broader multilateral agreement we can all come to relative to protecting heritage. Next slide, please. Space resources. Any exploration program to be successful is going to need to live off of the land. And that's certainly going to be as true, if not more so, as we go out into space, whether it's the moon or Mars. And therefore, the extraction and utilization of resources is going to be very important. And therefore, with the Artemis Accords, we're simply asking partner nations that work with us to abide by the Outer Space Treaty in terms of any extraction of resource operation, and to acknowledge that you can extract resources underneath the auspices of the Outer Space Treaty. Now, again, this can kick off and there will be a larger multilateral discussion about space resources per the Moon Agreement and what you do with profits from space resources and everything that comes after that. However, relative to the Accords, all that we're saying is that you can extract resources, you can utilize resources, you can enjoy the fruits of your labor, and further issues on that topic can be part of a future multilateral discussion and properly should be. Next slide, please. Deconfliction of activities. Here again is a terrific example of implementing obligations under the Outer Space Treaty. The Outer Space Treaty says to avoid harmful interference. How does one do that? What we came up with, and here I am borrowing generously from the great work of the Hague International Space Resources Governance Working Group. As a matter of fact, when text of the Accords is revealed, Guoyo, if you're out there, I wouldn't be surprised if you see some of your own language in what we move forward with. Again, that's why the Hague, I thought, was such a terrific effort to look at these issues and come up with ideas. I was actually the chair of Tiger Team 2 at The Hague, which dealt with safety zones. And we're trying to take a lot of that for the Artemis Accords. And all that we're saying with safety zones is that if you're going to avoid harmful interference, how do you do that? Well, in an area where there might be harmful interference, you need to notify, which you should be doing already relative to the registration convention, but notify where you are, what you're doing, at least generally, and coordinate to avoid harmful interference. Or as the Outer Space Treaty says, consult. Really there isn't substantively any difference between what we're saying with coordination or consultation. I don't know of any other way to avoid harmful interference than notifying about operations and coordinating to avoid harmful interference. It's what's required by the Outer Space Treaty. We're just implementing that. But I do want to be very clear on one point. These are not exclusionary zones. We're not trying to create any kind of sphere of influence that would keep people out of certain areas, because that would be in violation of the Outer Space Treaty. What we're trying to do here is implement the obligations of the Outer Space Treaty to avoid harmful interference simply by notifying and coordinating to avoid that harmful interference, as was discussed in The Hague, as is discussed in COPUOS. And here I want to be clear as well that what's been released publicly is a summary of the Accords. We are in negotiations, in discussions with international partners that are working with us on Artemis. Again, if you're a partner that wants to do something on Artemis, we're going to do a partnership agreement. All of our partnership agreements require obligations under the multilateral agreements that we've all agreed to. Here, we're just being a little more explicit relative to what those obligations are, how we're going to implement them, and then each country, there will be an annex for the specific activity that we're doing. But because this agreement will belong as much to the partner as it does to us, we can't come out right now with the draft text because the text isn't finished yet. We're still negotiating with the partners. They've got great ideas, great feedback. The Artemis Accords will belong to the partners as much as it does us. So I can't come out with the text yet. Therefore, please take the text you see as the summary as just what it is. It's summary. As a matter of fact, I commend Guoyo's piece in the Space Review, which I think was very well done. The only issue I would take with it is don't parse these words. As a matter of fact, a lot of what Guoyo was saying in terms of taking language from the Outer Space Treaty or from The Hague, let me just say, spoilers, I think you're going to like what you're going to see. We certainly do that in copious amounts relative to trying to parrot the exact language of the treaty or of what we did in The Hague in places. At least that's our expectation. We look forward to releasing the actual text as soon as those negotiations are concluded. And again, I think people are going to like what they're going to see, but please don't jump to any conclusions until you see that. Again, this is just summary text. Next slide, please. Orbital debris, we haven't done a particularly great job with the orbital debris issue here on Earth. We certainly hope to do better, as with this and many other things, as we move forward into space. And that's why we're going to ask partners who join us with the Artemis Accords to do better, have a plan for the passivation, have a plan for getting rid of debris that's safe and responsible per guidelines that have been developed by COPUOS. Again, you see us going back to multilateral commitments. So those are the principles of the Accords. We think they're pretty common sense and were written to be inclusive. We don't believe that any signatory to the Outer Space Treaty would have a problem with anything that exists in the Accords. As a matter of fact, they should be abiding by all of these principles already, with a few exceptions, such as the public release of scientific data, which we hope, if it isn't already, should become common international practice, if not common international law. I do want to point out, though, that there's a difference between the Artemis Accords, which are government-to-government agreements, and the rules that should govern the private sector. While much of this we think will be helpful to create an environment that's conducive to private sector development, such as just at least saying you can enjoy the fruits of your labor with space resources or creating an interoperable environment, there are a few aspects of the accords that the private sector shouldn't necessarily have to abide by, such as the full and public release of scientific data. That's not what a private sector entity does. So as different countries and as the US government looks at what the rules should be for the private sector, it may be different in some places from the accords, although we hope the accords set a very positive example for the world to follow. Again, I want to emphasize that we are trying to reinforce our obligations under the Outer Space Treaty. I think when you see the final text, you'll see that even more clearly than you do in the summary. We don't want to divide the world. We just want the world to take the Outer Space Treaty, the other multilateral agreements seriously, take these issues seriously so that we can deal with them now to prevent conflict in the future. The journey that we're going to be on is to the moon, but the ultimate destination of the Artemis Accords is a peaceful and prosperous future. So with that, I'm happy to answer any questions and turn it back to you, Daniel.
Thank you very much, sir. You've given us so much to think about and so much to talk about. So this is quite exciting. And I had a lot of questions that are already coming to mind, but I'm going to defer first, and I'll hand it over to Johnson. Chris Johnson, for those of you who might not already be aware of Chris Johnson, he is the Space Law Advisor at Secure World Foundation and probably my oldest friend in space law. He's a space law adjunct at Georgetown University and at the International Space University. And he and I both did internships at the Office for Outer Space Affairs many, many moons ago. Chris, what would you like to ask Mike?
All right, thanks for the introduction. And Mike, thank you for the presentation. I think, when we talk about Artemis Accords, we're thinking, about international law, their context in international law, their consequences for international space law. But those, academic discussions have to be grounded on the reality of what Artemis is about and what Artemis wants to do. So, and that's why at this point, it's, as you said, principles that will be refined depending on the mission and the project. Can you give us some type of indication of what type of things are actually going to be done on the lunar surface, or where on the lunar surface does Artemis want to go and some of the things they want to do? We're talking crewed inhabitation, resource use, etc. Some indication, because we need to know that to then have a better idea of the implications of these principles and what should be in the Artemis Accords.
Sure thing, Chris. And as we mentioned before, we all love the Apollo program, right? Apollo was wonderful. The problem with Apollo was that it ended. And where Artemis is going to improve upon Apollo is by creating a sustainable, permanent human presence on the lunar surface and around the moon. And if you're going to have a sustainable presence, you really need to do several things, including living off the land. So we need space resources. We need to have a better understanding of the environment. We need new power sources, new scientific discoveries to allow that vision of a permanent sustainable presence to conduct a new era, a new wave of scientific exploration possible. And just to whet your appetite for what that science could be, and no pun intended with the wet, we thought the moon was bone dry a decade ago. And now all of a sudden we discover that there's substantial amounts of water ice available. I don't know what the unknown unknowns are, but I guarantee you we have some extraordinary discoveries that have yet to be made on the moon. And if we're going to achieve that, then we need to move forward in a fashion, again, that's peaceful and respects the Outer Space Treaty. Again, this is all about implementing the Outer Space Treaty. So when it comes to space resources, that's why you hear us talk about space resources, that for a sustainable activity, we're going to need to have space resources. It's why we talk about the deconfliction of activities, that as you look at these water ice areas or permanently shaded crater regions, while the moon is a big place, there is the potential that whether it's a scientific exploration mission or some of the new commercial activities, that we could be in the same area. So it's important that we work out how to deconflict and avoid the conflict, as I mentioned before. And we want the whole world to enjoy the benefits of these activities, hence the public release of scientific data, and for it to be safe, hence interoperability and emergency assistance. So when you look at crew, living and working astronauts on the surface of the moon, these are all things that we're going to need. And I think you'll see how every provision of the Accords, every principle, is directly related to those operations. It would be great if we had multilateral agreements on all of these topics, ready to go, but I'm afraid that's certainly not going to happen by 2024, which is why we're just emphasizing that we are going to abide by these principles. We're going to ask any country that's a partner in the Artemis Accords to abide by these principles, and we hope that everyone else who goes to the moon also abides by these principles, and that it leads to multilateral conversations in the future.
Okay. Thank you for that. I just have one quick follow-up. Maybe you can answer it, maybe you can't. People are, and a lot of the reception of the Accord so far is people were hungry for further details, and they should have realized that this, as you said, is just the draft text or, principles, the highlights. But can you tell us today, maybe you can't, what other countries are being approached? What other space agencies are being spoken to? And if you can't, when will we hear some of this news? Any type of updates or insights?
Yeah, so unfortunately, I can't talk specifics. As you know, I spent most of my career outside of government. Coming in, I was surprised how challenging some of the internal processes were. But the reason that I can't talk specifics is a good one, because again, we don't want to get ahead of ourselves because we're still talking to partners about what the text should be, that we respect their input. We created some draft text. I can tell you it is substantially improved from the feedback that we received from international partners, and is still improving. It's still evolving from everything that we have seen. My hope is that you won't have to wait too much longer before additional announcements and perhaps seeing some text. But again, forgive me that I can't go on the record yet. Beyond to say a couple of things. One, we're making excellent progress. I have been extremely pleased with the response to the Accords. And two, while I can't get into the particular nations, I can just remind you that the reason we have the Accords is so that when partners join us, we all agree to operate by these principles and reinforce aspects of the Outer Space Treaty. So if a country is going to partner with us on the Accords, on the Artemis program, I should say, you can expect that they're going to need an Artemis Accords agreement, so that the countries that we're talking to are the ones that we were already engaged with in terms of supporting the Artemis program. Because again, the Artemis Accords are partnerships for executing programs under Artemis, and those are the countries that we are initially talking to, although we hope to broaden out beyond that. The beauty of the Artemis Accords, as opposed to the IGA, is we can have a much wider and more diverse group of nations working with us on Artemis than you could in terms of putting new countries into the IGA. So that's one aspect that we're really excited legally to be able to expand out the number of partners that we have. But you might imagine initially we have to focus on the partners that were already talking to us about actual programs underneath Artemis.
Great. Because that's, and I'll leave it at this, Daniel, this is the important point to draw from that, is that the Artemis Accords are not a one-way street where the NASA brings it to other agencies and says, take it or leave it, or it's being imposed on other countries. It seems he just indicated that there's room for improvement, innovation, iterations of what's in there. Although I hope that's not going too far, straying from the basic elements that are founded in the Outer Space Treaty.
Yeah, no, the principles are all still there, but just as you say, it would be so if it was a one-way street, I can tell you what's in the text right now. It's because of the fact that this is a partnership, this is a give and take, this is a dialogue, which again, the original text benefited greatly from. That's why I can't get into the text yet. And believe me, it's more frustrating for me than it is for the rest of you. And we look forward to finally revealing the text, because again, I think it's only going to emphasize everything that I'm saying today relative to respect for the Outer Space Treaty and supporting the multilateral commitments that we have already made.
Thanks, Mike, and thanks, Chris, for that. Now I'd like to pass you over to Ms. Una Sands, who is our international expert, our international legal expert. She is, for those of you also who, I think I'm probably introducing her to most of you, she's a duly qualified English and US lawyer, so that's extremely rare. She is also a senior, well, she is a senior associate at Fieta LLP and is she was named the Rising Star of Public International Law by Legal 500. Also a dear friend. Una, what would you like to ask Mike?
Thank you for the warm introduction, Daniel, and thank you to the Space Court Foundation for inviting me today. Mike, I would like to ask you about this safe and sustainable exploration of space and its development that you referred to in the context of space resources. I wondered if you could tell me whether the Accords will have any obligations to take measures to prevent, minimize, and control environmental harm of outer space itself. So obviously international environmental law is something that we think about, and it, well, I'll not get into what the ICJ has said, but I'd be curious to know if you can expand on that or tell us a little more about whether the Accords try to push things further in that regard.
I hate to pick favorites among my children. It's why I have only one son. But right after my love for the Artemis Accords comes some of the work that we've done, and it's a great question on this very topic of, we say the term planetary protection. I far prefer, and it's a little bit lengthier, but what we're really talking about here is preventing harmful biological forward and backward contamination. Bit of a mouthful. But sometimes when we say planetary protection, everyone always envisions asteroids and planetary defense, et cetera. So I always like trying to go to that more accurate, albeit more lengthy term of preventing harmful biological forward and backward contamination. So very important issue, but it is a good example of a place in the Accords, and again, they're still evolving, but I don't expect that we'll be highlighting that aspect. Now, to be clear, like everything else in the Outer Space Treaty, we will respect and abide by it. And part of the reason that we probably won't get too much into that in the Accords is because there's another forum where we have been engaging very aggressively on that issue, which is COSPAR. Which has traditionally led in that area. As a matter of fact, you might note that NASA recently released 2 new NASA interim directives, one for the moon and one for Mars, discussing this very topic, that we really didn't have rules in place, and still don't with specificity, relative to human exploration of Mars and what we do to prevent backward, harmful, and forward biological contamination. And particularly relative to forward contamination, a lot of our policies were based on obsolete rules that didn't even think about human exploration. So they were all based on robotics. We essentially would have been microwaving our astronauts prior to getting to the moon. And you know what prima donnas the astronauts are, right? They hate being microwaved to death, that they just want to keep their biologicals going. So there's inherently issues there that we need to look at. And what we did at NASA with that NID was stated that we need to review our experience on the International Space Station, which has provided a treasure trove of data, as well as the knowledge we're going to gain via the Gateway, lunar surface operations, and the robotic missions that we're doing to Mars. We're going to learn so much from what was Mars Month, right? 3 launches with the Emirates, with China, with ourselves, all sending robotic missions to Mars. And I think we're going to learn a great deal from that. And we need to take that information and then figure out how best to implement those policies for preventing particularly forward biological contamination as well as backward. And that's going to be leveraging all of that information and again balancing the interests, that it's important that we strike a balance to ensure safety and sustainability for human exploration while preserving the science, while preserving commercial activities, et cetera. So it's going to be very difficult. And as you're all talking about everything I've done in my past career, maybe I'll be retired by then. It won't be my problem as we go forward on that effort. But it's going to be a very interesting one. And we're laying the groundwork for that. So the NIDS that we developed are going to our national academies for them to chime in on. And then once we get the National Academy feedback, we'll create what are called NASA policy directives, which is the final position. And then the National Academies go back to COSPAR to have the international conversation. So a very important issue, likely won't be highlighted in the Accords because there's a separate path and forum.
Thank you.
Apparently that spacebar trick doesn't work so well. And now I think what many of us have been looking forward to is Goyo. You still there, buddy?
Yeah, saving the best for last
Best
here.
for last. Ladies and gentlemen, allow me to introduce Dr. Goyo Wang. He's the Associate Professor and Dean of Academy of Air and Space Policy and Law at the Beijing Institute of Technology. He served on the Chinese delegation to COPIOS. He was also the Chinese expert for the long-term sustainability guidelines work. And he has participated in both the Malamos project, which many of you probably know about, and the Hague Working Group, which was discussing this very exact topic. And in fact, I think at least four of you participated as well. So Goyo, with that, do you have any questions for Mike?
Okay, thank you, Daniel. Hi, Mike.
And Goyo, if you have any complaints, you have only yourself to blame because I was taking your stuff from The Hague.
Thank you so much for the very nice introduction. And some clarifications regarding the summary. As you said, that the Accord is trying to honor the Outer Space Treaty on one side. But as you know, you read my paper, from my perspective, it also just made some changes about the wording of the Outer Space Treaty. I do have, number of questions to ask you, but since most of them just reflected in the paper, I just would like to take this opportunity to ask something beyond my paper. If I understand you correctly, during the conversation between you and Chris, for the potential partner state or just formal partner state, still they have the chance to be involved in maybe development or modification of the Accord. Then how about the else of the world? I mean, whether NASA is ready to listen to the different voices, I mean, from the states who are not, the partner state of the program, but maybe potential partner states, of course. And another question is about some detail. Regarding the safety zone, how do you think about the space above the safety zone? Whether it's also included in the the scope of the safety zone? I mean, the space, of course, does not reach to a lunar orbit. Thank you so much.
So Goyo knows exactly the tough questions to ask, so that's very good. Let me back up, Goyo, to it, and if you don't mind, I can't help but respond to a little bit that was in your space law, space review piece, which again, very well done. And let me say for everyone who wasn't at The Hague, and I know a bunch of us were, really appreciate, Goyo, your contributions, and we often found ourselves in alignment, I think, you and I, relative to some issues that we were tackling in The Hague. And I just want to say, relative to the summary, and again, forgive me for repeating myself, much of what you said in that article, was pretty accurate. And part of it was driven by the summary was just literally that, summary text. And that I think when you see the final text, just as you were stating, why wouldn't you just go back to the language of the Outer Space Treaty, right? And I think, again, spoilers, you're going to see some similar stuff there. So I just wanted to address that. Relative to your question about other countries that may not immediately be working on the Artemis program, providing input, we absolutely welcome that. So any country, even if it's not immediately got a program under Artemis, we've reached out to a few. We would welcome anyone else from around the world coming in with feedback in terms of what they think. And that's why we did the summary, right? That, again, because this is a give and take, we couldn't put out draft text, which is unfortunate in some ways, but it shows our respect for the partners. So we tried to find a middle path, that we wanted to put out the summary to at least say, hey, this is what we're getting at, this is what we're planning to do, so that we could do exactly what you're describing. We could have a broader conversation with countries that wouldn't be directly involved in text, just to get good ideas and different, points of view, et cetera. And we look forward to doing that on a bilateral basis as well as in multilateral, forums, be it COPUOS. I was hoping to have been at COPUOS already, to have had a multilateral conversation about what the accords are, what they aren't. Obviously, with COVID, we weren't able to make that happen, and that's unfortunate because, frankly, I think we would have already been having this conversation if it wasn't for that on a bilateral and multilateral basis across the world. So very open to that feedback. Again, reading your piece, there was a lot of interesting things there, and we're looking for resources and opinions from across the world. So definitely open to it. Relative to safety zones, again, you make a great point, not only in terms of geographically distance up, but what about electromagnetic spectrum, right? Is that harmful interference? Is that included in a safety zone? And all I can tell you is I don't know. That part of the reason that we're proceeding with principles is that we're going to learn, right? We're modest enough to recognize we don't have all of the answers. And in many cases, we probably don't even know what the questions are. So that's why we just want to say the principle that we want to have a safety zone where we'll notify and coordinate what that ultimately looks like in terms of height, up or down, spectrum, debris. We kind of don't know yet. And that's why we're going to try and abide by the principle as best as we can, and then take that experience to the COPUOS and to multilateral forums. And as we have further discussions about what avoiding or preventing harmful interference means, we can compare notes with other nations that have conducted activities, and then hopefully all come together with our different experiences to craft multilateral agreements based on what everyone has done. So it's a lawyerly answer to say, we don't know, we don't have that defined yet, but I think it's an accurate one in that we need to be modest, that we just haven't conducted the operations yet. We're going to learn along the way. And we just wanted to create a system that was sufficiently flexible to allow for that learning period, and then for us to come forward in a multilateral context.
Thank you, Mike.
Mike, I know you're going to have to run here in a second, but just one last question. Our producer, Letitia Zarkin, would also like to ask you a question. Everyone, I know a lot of you have also been introduced to Letitia. Letitia is my former intern when I was at the UN Institute for Disarmament Research. She's been with everyone from SES to the European Space Agency, so she really knows her stuff. Letitia, you have the last question.
Thank you very much, Daniel, for the very nice introduction. And thank you, Mike, for your interest in the roundtable we are organizing today with the Space Code Foundation, and for the presentation of the Artemis Accords. I will have a question related to space law. May you explain us, under the Artemis Accords, who decides if a state is not complying with the Outer Space Treaty? Thank you.
Boy, you, Letitia, again, you asked the best question for last, right? And this is a issue that bedevils international law from the beginning and to today. What do we do when there's ultimately a disagreement? And even going back to safety zones, what do we do if there's a disagreement about safety zones or international law as a whole? What are the enforcement mechanisms? And I don't want to repeat myself too much in terms of what I told Guoyo with I don't know. But I think ultimately what it comes down to, in terms of a disagreement, like you would put forward, or any kind of substantial conflict, is it comes down to what the Outer Space Treaty says with consultations, or what we say in the Artemis Accords with coordination, which is just another way to say consultation, that it all burns down to ultimately the two parties talking to each other about it and coming to an agreement. And that's the genius of the Outer Space Treaty. And I think ultimately is not only how we resolve the question that you're presenting, but how we preserve peace in general. We talk to each other. So it may not be a particularly satisfying answer, but I think that's the way forward. Again, not only for your question, but for a peaceful environment in space and here on Earth as well.
Thank you, Mike.
Fabulous. I know that I'm probably the only one that you can hear clapping right now, but everybody out there is clapping for you, Mike. Mike, thank you so much for joining us. I know we're running out of time. We really appreciate you coming and giving us so much to think about. So we're going to spend the next hour or so chewing over and thinking about all the things that you just said. And thanks so much for also coming in the spirit of listening and learning and really trying to help us to understand better what NASA is trying to achieve and how we can leverage this to do, as you say, go forward in peaceful space exploration. So thanks a lot, everyone. I invite you to join me in thanking Mike virtually for joining us.
I appreciate the opportunity. I consider myself still a law student. I'm learning every day, just not paying tuition, thank goodness. Take care, everyone. Thanks, Daniel.
So with that, everyone, we're going to go ahead and continue with our original program. But fortunately, we've also got Gabe Sweeney. He's the attorney advisor for the State Department and also an authority on this issue. He's going to be on standby if we have any questions that we'd like to ask the U.S. government about this, about the Artemis Accords. But first, I'd like to go back to Chris. And Chris, can you please just give us some reflections on everything that you just heard and what your thinking is on the Artemis Accords?
Okay, well, I'll talk about two particular things in So the first thing is when I want to talk about freedom of exploration and use in Article 1 of the Outer Space Treaty. And, first, from the historical perspective, that right to explore and use outer space, including the moon and other celestial bodies, the freedom of access, exploration, and use. This is a right that wasn't a historical certainty. And it's not, and it is a right which had to be negotiated and agreed upon by states. So, did states enjoy the right to access space, simply as a consequence of their own inherent state sovereignty? What was there a freedom to explore space in, say, 1960, before even the 1963 Principles Declaration? Maybe there was, maybe there wasn't. But it is the state now, the current state of the law, the lex lata, is that states have the right to access, explore, and use outer space without asking permission of other states or without asking permission from the international community or the Security Council or the General Assembly. So say if a state chooses, and it's not mandatory that they explore space, but if they choose to exercise that right, they don't have to go and ask for permission or clear their program with other countries or with a community. So I think that was not guaranteed in the history of the development of space law, but that's the way that we have it now. I think that great right of Article 1 is what is then balanced with the obligations and prohibitions of later articles of the Outer Space Treaty. And I think that's important to remember. And I think that the other aspect that I like to point out about and this plays into how we think about Artemis Accords is that they do offer, some type of development of space law. And I think that that's where I'd like to hear from Una and Goyu about that, is that they, country A, the US, but country A wants to do particular things on the moon, and they're going to exercise their rights to explore and use space. In so doing, part of their accord, their agreements, just borrows and wants to just do exactly what space law permits them to do. But really, that's not enough. And they have to add a few other things like, say, interoperability, transparency, consultations, the concept of safety zones, use of space resources. Those are the innovations from space that they're adding to, because they look at what they want to do in space. They look at what they want to do on the moon, and they see that these innovations are to their interpretation, and Gabriel would have to defend this if he was pressed. They see that those innovations are in conformity and aligned with their rights under the Outer Space Treaty. They're not in the Outer Space Treaty, but they're aligned with those rights. So there's certain innovations that or progressive developments or iterations of space law or refinements or clarifications of their rights under space law that they're offering. And so I think that that will be the interesting things that the Artemis Accords do, the consequences of the Artemis Accords to the rest of international space law. So that's where there may be comment on and questionings, but if the United States sees that these are things that they want to do in space, that they're allowed to do, and fit with the Artemis program, well, this is their effort to make those refinements and expansions of space law. So I may, perhaps Una and Goyu have opinions on how they're doing that or the substance of them itself. But when I look at the principles of the Artemis Accords, I think that everything in there is in accordance with space law, whether it's explicitly or it, say, fills gaps or fills silences that already exist in the space law regime.
Thanks, Chris. That's really insightful. And I see Brian Israel rightly, as a good lawyer, pointing out to us that the freedom of access to space may be more of a freedom than a right, because the Security Council has limited at least North Korea's right to access space due to some of their missile technology and activities there. Now I'd like to switch over to Una to give us a proper legal discussion. Una, first of all, how are these bilateral agreements? Because the Artemis Accords are supposed to be bilats. How is that different from multilateral agreements? What are the advantages and disadvantages? What impact could these accords have on international law in general? And how do we reconcile differences of opinion that might arise between how the Artemis Accords are interpreting outer space law and how others might be interpreting it?
Thank you, Daniel, for those questions. And in order to be able to answer them, I'd need to take a step back almost, and I need to ask myself, how do the Artemis Accords fit within the broader framework of international law itself? Now, in terms of what the Accords say, they do reaffirm some pre-existing norms of international space law. As we've heard earlier, the language doesn't always mirror the OST provisions, but again, the text is not finalized. So that's one thing. At times I notice that the language does appear to go beyond what I see in the OST. I notice they don't mention consultation, which appears a lot in the OST, but again, that might come through in the final version. But to your question, Daniel, what do the Accords mean for international law itself? The conclusion that I've arrived at is that it's going to be very difficult to establish that the Accords reflect a uniform agreement of the parties to the Space Treaty, whether through interpretation, state practice, or customary international law. Due to the sheer number of parties to the Outer Space Treaty, state consent, of course, here would have to be inferred, but conditions will rarely, if ever, be such that state party silence or inaction may legitimately be characterized as tacit consent. And when I was thinking about your questions, I thought, I broke it down into just very basic issues of treaties, and then customary international law, and then anything else that might apply. So under Article 31.3a of the Vienna Convention, we have the notion of an authentic interpretation of a treaty, and that doctrine has its limits. It actually hasn't been applied very often in a judicial context. But to amount to an authentic interpretation of the Vienna Convention, the practice must be such as to indicate that the interpretation has received the assent of the parties generally. So the practice must establish an agreement. So it's not just any practice, it's practice from which it can be inferred that an agreement is established. And when I was looking through jurisprudence in preparation for this panel, I remembered the International Whaling Commission case before the ICJ, and that's a clear decision setting limits on, for example, unilateral regulatory decisions in favor of international cooperation and shared resources. And there the ICJ held that the International Whaling Commission resolutions adopted without the support of all states parties to the convention couldn't be regarded as a subsequent agreement to Article 8 of the International Whaling Conventions, and they separately said they couldn't be subsequent practice. Another case that sprung to my mind was the peace treaties case. That's the interpretation of peace treaties with Bulgaria, Romania, and Hungary. That was an advisory opinion before the ICJ. And here the ICJ attempted to demarcate the outer zone of permissible treaty interpretation. And it said that the rule of effectiveness cannot justify the court in attributing to the provisions in the peace treaties a meaning that would be contrary to the letter and spirit, because that would be a modification and not an interpretation. So this brings us on to the issue of the accords and those states that aren't parties to the accords, and what would their silence mean for international law. So as we know, silence or inaction on the part of states is capable of producing legal effects to establish an interpretive agreement for a treaty provision if the circumstances require a reaction. In my experience, that's much, much, much more common in a bilateral context for obvious reasons. And really the finality of the circumstances and a party's of awareness of it might be two factors. And interestingly, when a number of states submitted their comments to the International Law Commission, including, I believe, the United States on state practice, they adopted a relatively restrictive approach to the circumstances under which silence or inaction would establish an interpretative agreement of a treaty provision. So that then leads me on to the next provision, which is subsequent practice under the Vienna Convention. Now that subsequent practice, let's remember, is a term of art in international law. And the Vienna Convention says that when interpreting a treaty, any subsequent practice, which we could arguably be applied here, in the application of the treaty that established the agreement of the parties regarding its interpretation must be taken into account. So again, a practice that establishes the agreement of the parties, not just an agreement of a few parties. And it's important to distinguish subsequent practice from the wider realm of state conduct. So subsequent practice is really a subset of the wider notion of state conduct. And subsequent practice in the sense of the Vienna Convention, Article 31.3b, is an informal agreement between states regarding the proper interpretation of a treaty. And it would have to reflect the agreement of all parties, not just a few. And state conduct, on the other hand, is a bigger term, which would apply in the sense of the Artemis Accords, that would refer to how one or more parties implement the treaty or conduct themselves after concluding the treaty. And then again, the second and final point really is to do with the other source of international law, customary international law. And as we know, that's composed of state practice, which must be widespread, and opinio juris. So in a nutshell, you need a generalized agreement of the international community. And again, here the question would arise, well, in the context of the Artemis Accord, when can the other parties' inaction or silence be legitimately understood as establishing an agreement or acquiescence that the accords somehow give normative content that is binding on everyone else, and a minimum that have to have known of the action and have had a sufficient period of time to express their dissent. Previously states have raised several factors in that regard: the rights of the state, the knowledge of the practice, the timing, and the ability to act. And to be relevant, the inaction or the silence should derive from a sense of legal obligation or right. It's not supposed to come from non-legal considerations such as resource constraints, international or domestic political considerations, or diplomatic relations, say. That's not really what that notion gets at. And so I think custom is going to be much more difficult to establish vis-a-vis shared areas or res communis, that is outer space. It really is, I think, going to be quite exceptional. And again, related to what I've said are the concepts of, acquiescence and estoppel. So, where does this leave us? As we know, compulsory dispute resolution is absent from the OST. Query whether it is time to revisit that, if not through a court with permanent jurisdiction, at least through arbitration. Because without this, it really is going to be very difficult to arrive at an agreed view of the normative content of the rights and obligations of the OST. Who gets to decide what the standards are? And this is related, I think, to Letitia's question, who will decide concepts like harmful interference, due regard. And one of the things that is entirely possible is we're going to have a fragmentation of interpretation of the rights and obligations of the OST. It's entirely possible to see different countries or groups of countries coming together to follow different standards. And, without submitting to dispute resolution or without a subsequent agreement, it's very difficult to reconcile treaty text with what other states say is contradictory state action. And, again, there is the option of the formal method, which is an amendment or a protocol. So it wouldn't need to revise the entire treaty itself. Practically, yes, difficult, but much, much more conducive to certainty, I would submit. And I think in particular, if we are all interested in the rule of law in outer space, we really ought to give thought to dispute resolution when we see, where would we be without the jurisprudence on Earth? So let's think about that for outer space as well. So that concludes my answers to your first few questions, but happy if you've anything else.
If nothing else, that just kind of lays out the complexities of the introduction of the Artemis Accords into the rest of the discussion. So at least us lawyers are going to have lots of work to do for the coming years.
Can I ask a question to Una? Two small questions. From what I believe I understood, for the U.S. and other Artemis partners, Artemis Accords, you say, do constitute some type of interpretive guidance for their understandings of the treaties. Maybe just briefly, yes or no, whether yes or no. And then the other thing is, for non-Artemis Accords partners, their silence is neither dissent nor acquiescence to the content?
So obviously the states parties to the Artemis Accords, I mean, that's can be viewed as their interpretation. It doesn't make that interpretation an agreement between all the parties to the Outer Space Treaty. And one of the things we see in jurisprudence is you sometimes get the argument that, well, if you didn't say anything incopious, or if another state didn't object. And what I'm trying to articulate is that there are very strict limits on that, because not all states maybe have the resources. They might not, have a space capability themselves. So the concept has its limitations, and actually what falls under Article 31.3a and b of the Vienna Convention is much more limited. And that's why I tried in 31.3b to show the difference between state conduct and state practice. Because really, when we're talking about the Vienna Convention, we're talking about what establishes the agreement of the parties. And based on what I've seen so far, there is enough discord among member states that at least in COPUOS and several issues, for example, on space resources, that I don't think it's an attractive argument to say that the Artemis Accords would reflect the agreement of all the states parties.
Thanks, Chris. Can you hang on to your next question for after Goyo speaks? Unfortunately, it's pretty late over where he is, and I'd like to at least give him a chance to respond initially to Mike's comments and his responses, and just give us his views. Goyo, you've said a lot in the last couple of days. Also, the Outer Space Institute up in Canada just came out with their letter, where a lot of prominent Canadian officials have just called on the United Nations to start working or negotiating on a framework. They didn't say treaty, they didn't say guidelines or codes, but a framework for lunar exploitation. You also signed that letter. So, sir, how do you see the Artemis Accords working in tandem with multilateral discussions, and ultimately, how do you see this impacting U.S.-Russian or U.S.-Chinese relations? Hang on, you're muted, sir.
Oh, sorry. Yeah,
There you go.
No, yeah. Okay, so you can hear me now, right? So I just would like to a little bit introduce the background of the so-called Canadian proposal. So as a matter of fact, it's an international letter on space resources utilization, which was already submitted to the UNGA president several days ago, maybe just within the week. It's just initiated by, as you said, Outer Space Institute of the University of British Columbia, and drafted by some of our Canadian colleagues. So the main purpose of this proposal, as stated by itself, to urge states to present for adoption at the UNGA, a resolution which would request COPUOS to negotiate with all deliberate speed a draft multilateral agreement on space resources exploration, exploitation, and utilization for consideration by the GA. So for me, basically, it just proposes a multilateral approach under the auspices of UN to formulate an international legal framework or legal regime of space resources activities. Thus, it's the first point, which is different with the accord. The accord just adopt, a bilateral or multilateral model led by one state and is beyond the UN framework to get consensus on the relevant legal issues. And the second difference is that the Canadian proposal just paid more attention to developing countries and argue they are deserved for equal chance to be involved into such discussions. However, the accord seemingly does not offer such kind of opportunities to them. It rather aims to cooperate with capable state to explore the moon together and share the legal opinion together. So the relations, the possible influence on the Sino-American relations. So first, for me, it's tough, but I think it's still too early and remote to say the accord would affect U.S.-China relations, no matter in space or on Earth. So first, whether it could affect the Sino-American relation in space is still under observation. It somehow depends on whether it's open to China, either for substantive participation or for further discussion on the possible development of the accords, because as Mike said, it's just the summary. So the whole text is still under drafting. And second, I believe that the bilateral relations in space are interacted with the ones in other domains regarding the China-US situation. First, things like arms control, cyber, trade, and the South China Sea, and so on. And I see deterioration in other fields relations might affect Sino-American relations in space negatively. But on the other side, hopefully a turn for the better in Sino-American space relation might warm up the relations of the two countries on Earth. So basically, I just stop here.
Thank you very much, sir. And I agree with you that the relations in space do tend to reflect relations down here on Earth. But if the Cold War showed us anything, that outer space does provide good opportunities to try and bridge those divides. I know most of you can't see him up here, but this is Alexei Leonov, one of my heroes, largely because he helped orchestrate the first international handshake in outer space when the Soyuz and the Apollo, when the spacecraft came together for the first time in space. So there's a lot of stuff that we're throwing out right now, and I know there's somebody in the audience who would be very interested in at least responding to some of these things that we've been throwing out. I think right now at the moment we're asking a lot of questions, and the Artemis Accords really do bring up a lot of issues. So before we settle on what they're going to be or get a better sense, it's good to know which questions we need to ask. So as I said, we've got Gabriel Sweeney. Gabe, you're a presenter now, if you'd like to turn on your camera. There's a lot that just came from Chris and Una and Goyu. Is there anything that you would like to say?
Can I say something about the interpretation? May I?
Yeah. While we wait for Gabriel to turn his mic. Sure. Go ahead, Goyu. No, Goyu, go ahead.
Okay. So we discussed a lot about the so-called legality or legitimacy about the interpretation in the accord to the Outer Space Treaty. But I'm afraid that we might just discuss a fake issue, because for me, interpretation is how to say, for instance, like Article 2 of the Outer Space Treaty. If you argue, okay, so the non-appropriation principle also applies to space resources, but only space resources in place. I agree, it's a kind of interpretation, but at least the summary just right for me. I would like to say it's changing. It just changes some wording of the Outer Space Treaty. It's not interpretation. Or if you would like to create something new from a Lex Ferenda perspective, that's fine. But it must be something new beyond the Outer Space Treaty. Something is not mentioned in the treaty. However, if some issue is just expressly stipulated in the Outer Space Treaty, for instance, like the peaceful purpose, exclusive peaceful purpose, or about the rescue of the astronauts. So in this regard, I do think that the Accords is seemingly not trying to interpret some ambiguous, in the treaty. It's just to change the wording and create something new, which is different with the the expression in the Outer Space Treaty. So, and another thing I would like to say is that about bilateral or multilateral agreement. So if it is interpretation or creation of new rules, no matter in bilateral or multilateral agreements, it's totally fine. Because again, according to the Vienna Convention, it could be even as subsequent state practice in the application of the treaty, could be taken as the interpretation of the specific rules. But it still is very dangerous to change the treaty language, no matter, again, in bilateral or multilateral approach. I just stop here. Okay.
Well, with that, Gabe, I think you got left with the most unenviable job. There's lots to do there, and Mike has left plenty on your plate. Please, sir, comments?
Sure, I'll do my best. Yeah, Mike and I have been tag teaming the Artemis Accords for a while, and I guess my job is to clean up when he leaves. No, there's lots of great questions, and I'll try to address them in a way that makes sense in terms of order. and I'm sure I'll miss some stuff, but feel free to ask me. For those of you who don't know who I am, like you heard Gabriel Swinney, I'm an attorney advisor at the State Department. I cover our space law portfolio, and I work closely with Mike and the NASA team and the State Department policy team on international space law issues. Sorry? What was that?
Great background.
Yeah, so I get to talk about this fun stuff all the time. So in terms of maybe I'll work backwards. In terms of the Outer Space Treaty, Goyu raised some important questions, as well as Ona did, about how the Artemis Accords interact with the existing legal regime set up by the Outer Space Treaty, and are the principles set out in the Accords consistent or different, or are they trying to change the Outer Space Treaty? What exactly are we trying to do here? And I think Goyu and others have accurately noted that the summary, certainly that's online on the NASA website, sometimes does not use the exact language of the Outer Space Treaty. Just, I think Mike already said, with regards to the summary, that was a summary for essentially press and public consumption. So I think I wouldn't put too much into the words of the actual summary in terms of internal US government stuff. That was made by the outward-facing press people. That's not something that sort of we on the legal team drafted and stuck up there. So the words that you'll see in the actual text that's being negotiated ultimately are different. Many of the principles, as Mike said, in the Accords are, well, some of them are actually just directly verbatim from the Outer Space Treaty. So that's one. Sometimes things like with regards to rescue of astronauts, we just felt it was particularly important to reiterate them, but not sort of play with the language at all, because we thought the rules as they were set out in the Outer Space Treaty were pretty much as far as we would know how to go for now. There's a few other cases, like with regards to deconfliction of activities, where we absolutely will adhere to the Outer Space Treaty and agree with all of that. But what we're trying to do is to say how, right? It's not that anyone's trying to change the rules, far from it. We're trying to say, how do you do that thing that's set out in the Outer Space Treaty? Some of you may have heard the remarks I gave a couple years ago at the Galloway Symposium, for example, about due regard. And I asked this big question to the space law community. All right, it's in Article 9 of the Outer Space Treaty. It says we have to give due regard to the corresponding interests of other actors. How do you do that? And as you know, as we see lunar operations and operations going on to Mars actually coming sort of in the near term, we lawyers are faced with the question of what guidance do we give our clients? What guidance do we give the policymakers and the engineers who are designing these operations, right? As Chris said, as Chris Johnson said at the beginning, you know, these are activities that are permitted by the Outer Space Treaty. It's not like these are things that we've sort of come up with that no one's been talking about. Exploration of the moon, we know that's permitted. The US has a longstanding position that space resources utilization is also permitted. So from our perspective, these are activities that we can do right now. So we could just go do them, right? And not coordinate with anyone and talk about it. We could just sort of go do them. But we think from a legal and policy matter, it's much better global citizenship and frankly, a better way to adhere to the Outer Space Treaty to drill down one or two more steps and say, okay, if this is what we're going to do as a factual matter, and we know what the Outer Space Treaty says, if those are sort of high level principles, what literally does it mean then to do those Outer Space Treaty things? So we're not trying to change the interpretation. We're not trying to create new rules that didn't exist before. It's the exact opposite, actually. We're trying to provide guidance to our operators. So I think if you sort of take away anything from this, I think it's that from a sort of the internal US government legal perspective, we're just trying to answer the mail from the perspective of our engineers and our policymakers. They need guidance from us as lawyers to say, what does it mean to exercise due regard? How far apart do you have to be? What does it mean to have an obligation to rescue actors when you're in a new location, right? All of those things. So that's the real driver. No one's trying to change the rules. We're just trying to answer some of those questions that have existed for many decades. In terms of bilateral versus multilateral, I don't want to get ahead of the discussions we're having with our partner countries. But I think what I can say is that you're likely to see, I think there's a good chance you'll see two things, sort of a two-step in terms of the accords. The negotiations that we're engaged in are both at a bilateral and multilateral basis, right? Because of COVID, it's difficult to all get in the same room at the same time. So we're doing all of this remotely. We're talking with our, the partners that we work with in terms of actual operations in outer space. And we do intend to have conversations on a multilateral or multi-country basis with those partners as well. And I say those partners because, again, keep in mind that this is answering the mail with regards to specific operations, right? The Artemis program isn't just an inchoate concept. It's actual operations with particular countries going to do particular things on the moon and then onto Mars. So it's absolutely true, as Mike said, we want to have a big tent. We want to talk with lots of countries. But in terms of what's the operational need, the immediate need is to have a shared set of guidelines for how we act with our partners, just because those are the people we're going to be on the moon with. We're literally going to be doing things with them. So it's important that we have a shared understanding of how to behave once you're there. So it's not that the United States is trying to shut anyone out of this conversation. It's really more that we have a practical problem here that we lawyers need to give guidance to on certain operations. So what that results in terms of process is that we'll have the conversations at a bilateral and multilateral basis. I suspect what's going to come out of that is some kind of joint single text that's sort of jointly supported. The Artemis Accords that multiple countries, the United States and our partners, we would jointly support. That may well be a multi-country document. But then when it comes time to do particular operations, say land a particular rover on the moon or send a robotic sampling mission to Mars or something like that, right? All of those of you who've been involved in space cooperation, you all know those are all wrapped up in bilateral cooperation agreements. We do these routinely all the time. NASA enters in dozens on dozens of these that set out, who builds what and when are you responsible and liability and all those kinds of operational issues. I suspect those bilateral operational agreements that are really about the technical stuff for particular missions will themselves then reference back to the Artemis Accords and say, I'm just making up an example, but as we, the United States and Canada, land this rover on the moon, we will do so in accordance with the Artemis Accords and the principles set out therein, something like that. So I think you'll end up seeing a multi-step or a tiered approach to this, where you have the higher level multilateral agreement sort of then baked into individual cooperative agreements. I'll stop there. I mean, I think that once you have that approach in mind, the idea that we really are trying to meet an operational need, I think that helps you get to the answer for some of the other questions. As Mike said, absolutely open to conversations with China, developing countries, all kinds of emerging space countries and others. But because we don't see sort of immediate specific cooperative projects on the near-term horizon with some of those countries, our focus hasn't been there right now, just because, as I said, we, the lawyers, are trying to scramble and keep up with the incredibly fast pace on the engineering and policy side of the Artemis program. So I'll stop there, but I'm happy to address anything else, any other questions you all might have.
Una, Chris, Guayo? Una has a question?
Yes, I have a question. Thank you, Gabriel, for your remarks. Given how much more activity we are going to be seeing, has the time not come for some sort of compulsory dispute resolution mechanism? Given you may have heard my remarks in which I said that the potential for differing interpretations and differing views on conduct on the part of one or more states, and bearing in mind that there are obligations erga omnes in outer space, has the time not come to think about that? And how will we have legal certainty otherwise?
So trying to think how to organize my response. Sort of maybe three points in response. And I did hear your remarks, and you know, the law student in me, or if I could travel back in time and talk to the law student I was, would be all for compulsory dispute resolution, right? When you're not in the middle of these things, it seems like a clear answer because it does offer all kinds of benefits. I think in the real world, we have seen compulsory dispute resolution not be terribly successful, with some clear exceptions to that, right? Having to do with like maritime boundaries and things like that. There are certain topics that find themselves particularly amenable to compulsory dispute resolution through the ICJ or some other mechanism, trade agreements, stuff like that, where there's a well-developed body of international law and practice. We sort of know how to do those things, and it's just a question of answering the question, right? Applying the law to the facts. I don't think that's where we are with regards to space law. We have very high-level principles in the Outer Space Treaty that don't provide a lot of detail. We have a liability regime that sort of says, well, it's a fault-based liability regime in outer space, but then kind of throws its hands up and says, nothing about what the actual standard is for fault. And then we have lots of new activities that are taking place on the moon, in cislunar orbit and beyond, that has very little practice on these new activities. So even if I think that compulsory dispute resolution is a good idea in concept, I don't actually know how we would do it now. I don't know how you would go to a court or an arbitral tribunal and say, please apply the law to this set of facts, because we have no standards. We have no well-developed state practice or legal standards on which to make some kind of a judgment. So I think absolutely you could imagine particular questions being amenable to that at some point in, say, the medium term. But until we develop that additional practice, I just don't know how you could, my own father's a judge, and not internationally, but it's just knowing judges. If you submitted a question to someone, to a court, I just don't know how they would answer these questions right now. So I think what states have to do now is to do their best to implement the obligations, work together to further develop what those rules mean. And then you take another look, in 5 or 10 years, and you say, okay, this is what we've done. These are the standards that have developed. And we do see standards developing through multilateral and other processes, through the UN, for example, on long-term sustainability and debris. You could imagine those developing to a place in which you could have legitimate judicial review. But at this point, I just don't see it as workable.
So can I have a follow-up? I mean, I think actually the what you've set out could actually be said in support of my argument. When you say that there's a lack of detail and the high level nature, that to me seems perfectly amenable to a court or tribunal ruling upon that. That's actually how we've been able to progress a lot of international law, is through that very method. And also, the international legal community is perfectly aware of the great need and deference to the scientific community. But for example, with environmental law, we can't say, well, we don't know enough yet, that, that's why that precautionary principle came into place. So I think, and in the context of, for example, law of the sea, we saw that the ITLOS had its advisory opinion by the Legal Fisheries Commission. So there's also, I think there is a lot of scope for at least arbitration, if not through submitting to a permanent court. But I don't see how a group of states saying that this is what conforms to the treaty and no one else is able to do anything, or we're not able to get normative content and clarity. So, there could be a group of states that take a position very different to that of the United States. And how is that going to work out? Where will that leave us in terms of certainty?
Yeah,
So
Gabriel, if you don't mind, I would like to, I could see Goyo maybe drifting off to sleep. So good sir, I would like to give you one last opportunity to chime in. And then if you need to go, feel free. We are coming up on an hour and a half. I don't know how everyone's doing. Are we still feeling fresh? Okay.
I just make it short, okay?
Hi,
Gabriel. Nice to meet you here again. So I'm not quite clear about the consistency between the Accord and the Outer Space Treaty. As you mentioned that the Accord has no intention to change the wording in the treaty, but it does happen. If I remember correctly, during our discussion in the Hague Working Group, sometimes we are in the same boat when some colleagues, they were trying to create something new, changing the wording of the Outer Space Treaty, such as space resources shall be used exclusively for peaceful purpose. I said, no, it's not exactly the same saying of the treaty. It shall be, okay, the moon and other such bodies shall be used exclusively for peaceful purpose. And I remember at that time, you were in line with me, but of course our proposal were rejected by the working group. Anyway, But again, in the accord, the wording just shows as a peaceful purpose. I understand that, of course, regarding the Artemis program, of course, is a series of activities, not only the activities on Saturn but on the moon. But the gravity of the activity, of course, just refers to the space resources activities on the moon. So in this regard, actually, exclusively for peaceful purpose, the term shall be mentioned, but it's just disappeared. It's changed to a peaceful purpose. And regarding the emergency assistance, as you just introduced, actually, if we just, first, you see the accord does not mention Outer Space Treaty in this specific principle. It just mentioned the rescue agreement. However, it's just use a different wording with the Outer Space, either the Outer Space Treaty or the rescue agreement. It just use the wording, all reasonable steps, all reasonable steps. It's different with the one in the Outer Space Treaty, it's all possible assistance, and different with the one in the rescue agreement. Is take all possible steps rescue and all possible assistance. So, and regarding the scope to be rescued, of course, in the rescue agreement is use the term personnel of the spacecraft, but in the accord, it just used the wording in the Outer Space Treaty. It's just limited in the scope of astronaut. So from a purely, the legal perspective, it does make some changes there, no matter it's intentionally or just omission. And the last point is regarding the safety zone principle. Hold on a second, please. The first sentence of that principle is said that avoiding harmful interference is an important principle of the Outer Space Treaty. Again, I remember during the discussion in the Hague Working Group, I also the one objected such kind of saying. If I remember correctly, you also supported my suggestion at that time, because it's not exactly the same saying in Article 9. So the potential harmful interference, when it just referred in Article 9, it just trigger international obligation regarding consultation. It said that if a state has reason to believe its activity would cause harmful, potentially harmful interference with another state, it is obliged to take some appropriate international consultation. But it definitely is not equal to to argue non-harmful interference per se is a principle expressly set up in the Outer Space Treaty. So, just to put it in short, regarding the 10 principles in the accord, some of them just, as I said, change the wording of the Outer Space Treaty, and some of them could be taken as best practice, like the transparency or the release of scientific data. But some of them just, I'm afraid, would trigger the interpretation of the wording of the terms in the Outer Space Treaty, like non-appropriation or the freedom to access, like the protecting heritage or the complication of activities. So can I have some further maybe clarification from you in this regard? Because I'm a little confused. As you said, it's just the court just adhere to Outer Space Treaty, but I'm afraid I do not see in the same way. I just stop here. Thank you.
Chris, Gabe, both of you open it up for responses.
If Chris wants to answer, that's fine with me, and then I can jump in.
No. This is your job, Gabriel.
Thanks.
Although it feels a little bit like a Millamos meeting as also, because I know that yeah, we've both been at Millamos.
Yeah. So Goyu, thank you. And I'm scared and impressed that you remember so much of what I say at other international law fora.
Also email
And I actually think your point is a very good one in terms of showing the international community what we're trying to do with the Accords. And I'll reiterate a couple of the examples that you gave about some conversations we did have and where you and I agreed at the Hague Space Resources Governance Working Group, because I think they're very instructive about what we're trying to do differently with the Accords. It's absolutely true. I remember at the Hague group, you and I both objected to some of the phrasing regarding harmful interference because it didn't track the language of the Outer Space Treaty. I think maybe we've had similar conversations, or maybe it was separate, about some stuff about having to do with protecting heritage. And there were some other items as well. So it's absolutely true that I think the United States government would have concerns if a body that we were not part of, or that was sort of separate from the intergovernmental process, tried to create standards that were stricter than those set out in the treaties to which we're party, right? So a concern with the Hague Space Resources Group was that if they elevated the concept of non-interference beyond what's in Article 9 of the Outer Space Treaty, that would impose an obligation on the United States government that we did not sign up to. Now, what we're trying to do with the Accords is very different. We're trying to ourselves agree to higher standards. So from the perspective of a sovereign, from the perspective of a government, there's certainly nothing wrong in international law for us to say, yes, there's an international legal obligation set out in the Outer Space Treaty. That's our floor, right? But if we want to be even stricter with ourselves and hold ourselves and our partners to even higher standards, there's certainly nothing prohibiting us from doing that. And that's exactly why you see some places in the Accords where the language does differ. Unless I've missed some, the way we've tried to draft it, and this was certainly my goal when Mike and I were writing a lot of this together, the goal was to either implement the obligations purely where we think the obligations already provide enough guidance, or in a few cases where we think we want to hold ourselves and our partners to a stricter standard, to come up with a stricter standard that certainly meets the obligations in the Outer Space Treaty, but actually goes a little bit further. So deconfliction, the one you mentioned there, is a great example of that. You're absolutely right about what the Outer Space Treaty says. It doesn't say you can't harmfully interfere. It just says you should consult before you do that. But we're going to say in the Artemis Accords, we want to say, no, seriously, we ourselves have committed to not harmfully interfere. And before we would have any interference, we agree to consult and provide notice in advance. So I hope that's the kind of thing, holding ourselves to a higher standard than we're legally obliged to do so. I hope that's the kind of thing that other countries would support, or that other space actors would support. So I think that's a fundamental difference of sort of who's making the rules. We're perfectly capable of holding ourselves to a higher standard and expect our partners to do the same. We could talk about the specific phrasing of some of the others, the rescue and peaceful purposes stuff. But mostly I'll just say on those, thank you for your close textual analysis, and we'll take some of those back. No one's trying to do anything, by the way, in terms of the not having the word exclusively for peaceful purposes. I think, frankly, that was just a drafting choice we did to make sentences shorter. I'll just go in this afternoon and stick exclusively back in there. If that's a thing that bothers people, that's an easy fix to make. So no one's trying to do anything nefarious or sneaky there. But so I guess that's what I'll leave you all with, is just we're trying to either implement the pure provisions of the Outer Space Treaty, or take a couple baby steps more and hold ourselves to a higher standard with more detail, not because we're trying to change it, but because we believe in those obligations. That's the heritage, the protection of human heritage, for example, right? The Outer Space Treaty says nothing about human heritage, but we expect ourselves and our partners, when they go to the moon or somewhere else, not to run over the footprints, not to run over rover tracks or crash into equipment that someone left behind. Not because I actually think there are arguments you can make from the Outer Space Treaty, but not just because it's set out in the Outer Space Treaty, just because it's the right thing to do. And that doesn't mean that it somehow automatically becomes binding on the rest of the world. We know it doesn't. It's just something that we expect ourselves and our partners to do because we think it's the right thing to do. So I don't see any problem there, any tension with what's set out in the Outer Space Treaty when we impose higher standards on ourselves. Ona's point is with regards to, is there a danger of splintering interpretation of international space law? Yes, there is a danger of that. Hopefully we can avoid that. Hopefully we can explain ourselves well enough. We think that the principles we're coming up with are not things that would be objectionable. We think they're the kinds of principles that other major space actors, such as China and India and Russia, would agree with if we could get past the geopolitics. So we don't see that as inevitable. It's 100% a danger. That's why we're willing to talk about it whenever anyone wants to listen. And it's why we want to, as soon as we get through the sort of behind the scenes negotiation, which is just a function of how diplomacy works. But once we get through that, we're going to be here showing the accords. Nothing's going to be behind the scenes. It's all going to be public. So it's a danger and one we really want to work hard to avoid. And that's exactly why we're here.
Oh,
Chris.
thank you. Can I have a hard pursuit
Oh.
there, Danny?
Yeah.
No. Up to you.
Well, hang on. Let's let Chris follow up. Thoughts, sir?
I always like a hot pursuit, so I'm gonna go you the floor. If you can make it brief, though.
Thank you so much. Hot pursuit. Regarding the high standard or strict standard, I think personally I can understand it. The only concern here, the higher or stricter standard to whom? I'm just afraid it would just set up some unnecessary threshold, maybe to some developing countries. The concern have been raised during the LTS discussion for many times. And the second point, regarding the interference, I agree with you. If you take it as a principle, you do just set up a high standard. But the problem is that in the accord, the summary, it's just that it is the principle in the Outer Space Treaty, but that's not true. That's my point. You can create a new principle, no problem, but it's not the truth in Lex Lata. And the third point, talking about higher standard, for me personally, again, exclusive for peaceful purpose is a higher standard than peaceful purpose. But that's just the wording, for me, it's a lower standard, the wording used in the accord. It's just the peaceful purpose. It means maybe some military space activities is legal on celestial bodies. And another one is about, the scope to be rescued. Personnel, I think, is a broader scope than astronaut, also including maybe crew members, depending on different domestic law. So it's, for me, the accord, again, the summary just narrows down the dual scope to be rescued than the one in the rescue agreement. I just stop here. It's your turn, Chris.
The moral of the story here is that you can never win with lawyers. Chris, you had something to say?
No, those are questions directed at Gabriel. If he has a response to that, if he doesn't have a response to that, then I have a couple questions for everyone I'd like to consider, and they're based off of the questions that we've got coming in, which are pretty interesting. But Gabriel, if you have a response,
just really quickly, I've already said I'll go back and look at the specific phrasing in the current working draft about the exclusively for peaceful purposes. Like I said, no one's trying to do anything weird here, so we may just well be able to fix that based on how the grammar works. As far as the rescue and return agreement, we could have a whole conversation about this. If you look at the rescue and return agreement, the way it's phrased, which obligations apply to astronauts in distress in space versus which obligations apply to astronauts in distress when they land, that language is extraordinarily confusing, the way it's phrased in the rescue and return agreement. So to the extent there's some confusion, Goyu, about what the obligations are in space set out in the Artemis Accords, that's actually why, because we've just sort of been spinning on trying to parse the meaning of the rescue and return agreement itself. So I think it's great to force us to revisit that. The goal is certainly not to lower the obligations. The goal was actually to take a baby step and make the obligations firmer, and to make the obligations that apply under the rescue and return agreement for astronauts that have like splashed down in your territory or something, essentially make that standard, which is pretty high, apply also to astronauts in distress in orbit. And it's 100% possible that I've screwed up that drafting, but that's what we're trying to do. And so I appreciate you pointing that out. We'll take a look at it.
All right.
Chris,
I want
to ask the group a question.
Well, there's, great questions from the chat, and I apologize to folks that we didn't get to them earlier, but this question from Michael Maloney, he says, and I agree that this is important, the Outer Space Treaty is 53 years old. To the extent that space activities have occurred, why are the Artemis Accords held strictly just to what the treaty language is, ignoring 53 years of accepted precedents in space activities? So I would, expand on that saying, doesn't 60 years of space activities give us some indication of what due regard is, or consultations? Don't we kind of know? Don't we have state practice of decades of consultations? So these things are not merely that we look at the Outer Space Treaty and say, well, we don't have further guidance. We do have guidance from actual practice in space.
I guess I would say when you look at practice, we have extensive practice on some things and very little practice on others. So with regards to spectrum and radio frequency interference, we have tons of guidance, right? We have entire legal regimes set out through the ITU. We have a geostationary regime, but even for LEO activities, it's not just a deconfliction mechanism, it's internationally legally binding rules. And you could certainly read those as giving effect to the due regard obligation. So we have extensive practice with regards to radio frequencies. But then contrast that with a situation where, for example, orbital slots in low Earth orbit. Basically, the practice is you go up, you launch, then you get your information from space situational awareness agreements, and then you just kind of dodge each other and hope that everything works out. So yeah, there's practice. It's probably terrible practice over the long term. But it doesn't really give a lot of guidance. And I don't think that's the kind of model you would want to export to like a whole new orbital regime, say cislunar space. So I think it really becomes very fact specific. Do we have practice on certain things? Yeah, we do. And some things we have a little bit of practice on, like space resources, right? The United States and the Soviet Union did take space resources and brought them back. And some of those things have changed legal title, but it's not a lot of practice. So it just depends. It's not like you can't say, is there or is there not a lot of practice for the Outer Space Treaty? It just depends on the topic. So that's why it becomes a very...
Una, did you have a follow-up on that?
Can I say something about old Outer Space Treaty?
Hang on. I'd like to hear from Una real quick before we shut things down. We're getting close.
Yes.
Okay.
So I mean, I'm throwing this out to everyone. But on my reading of the Outer Space Treaty, I don't think the utilization of space resources, the unilateral or the exploitation by one party, I don't see that as compliant with the Outer Space Treaty. And I think a number of you heard me speak on this before, and the Artemis Accords, they say that resource extraction and utilization can and will be conducted under the auspices of the OST. I mean, there are very weighty legal arguments in support of the contrary view that it does not accord with the OST, and there are certainly several states that are not party to the Moon Agreement that disagree on that issue. So, I mean, what do we make of the fact that we have a set of nations that are saying, well, yes, that does accord with the OST, and then you have a number of different states saying no? I mean, that to me seems an area that's ripe for conflict. And is it not something that should be approached with the utmost of caution in terms of whether to do it? There's also the issue of when it's done, how will it accord with the corpus of international environmental law? And we saw in the nuclear test case that the ICJ confirmed that applies to areas beyond national jurisdiction. So my question to everyone is this a satisfactory state of affairs? And are the accords, as based on the summary that I have read, a desirable state of affairs?
Hang on, before anybody starts answering, that's a huge question, and I do think that we need to probably leave that one for next time. I will ask Goyu to just wrap up any final remarks, and other thoughts that we can take away. And then for everyone else that had questions, sorry, this conversation really got away from us. Well, it didn't get away from us. We really got into it. But we will be taking all the questions that are in the Q&A, and I'll send them out to everyone who spoke today. I don't know if Mike and Gabriel will be able to answer some of those, but certainly I think our other speakers will try to get to them. So Goyu, with that, I'll give you the last word, sir.
Okay. So I should be very cautious now because it's already the 3rd o'clock in the early morning in Beijing. And besides, as Mike said, it's just the summary, just a summary. So I would like to make a conclusion just until I see the whole text, I mean, of the accord. But basically, as the final remark, I just hope first, the language in the accord regarding the relevant articles in the Artemis Treaty, I hope still we just do our best to keep the consistency with the treaty language. And the second point is that if something is necessary, I mean, something new, of course, could be discussed and created if necessary. And the third point, last point is about interpretation. I hope I can see some the real interpretation about the principles or the obligations, you know, which are not so clear in the Artemis Treaty, could be maybe elaborated or clarified in the accord. Then I think it might be served as a very good basis for further discussion, no matter bilaterally, multilaterally, in particular in the UN COPUOS discussion. I stop here. Thank you.
Thank you, Goyu. Thank you, Gabriel. Thank you, Chris. Thank you, Una. Thank you to the Space Court Foundation. Letitia, you did a great job as always. Thank you so much for taking care of all of us who are over 30 and don't understand technology. And thanks so much to everyone who attended. I think we had a really stimulating discussion just now. We've asked a lot of really great questions. And as Mike and Gabe have both said, the Artemis Accords are still evolving and they're still being put together. So hopefully some of the discussions we've just had will feed into that. And we really look forward to seeing what comes out. I also want to thank all of my speakers. Again, this was a really civil and intellectually stimulating conversation that was also quite respectful. And I think this is the way that we really have to drive discussion and dialogue. We all come from different backgrounds. We all have different perspectives and views, but we have to be willing to talk to each other and respect each other more than anything. That's a big deal these days. So thank you very much to everyone. Let's call it a day. That's enough talking about lunar mining for at least this morning. Thanks, everyone.
Thank you and good morning.